Separations of powers was a recurring topic at the Philadelphia Convention. Although the structure of a three-branch government was agreed upon, the functions of each branch was more controversial. Some powers did not seem to fall solely in the executive, legislative, and judicial branch. James Wilson, for instance, believed that the powers of war and peace belonged in the hands of the legislature rather than the executive. After much debate, this power was divided to allow the legislature to declare war, giving the executive enough leeway to enable him to repel sudden attacks, as stated by Pierce Butler at the convention. The Senate, in addition, must approve treaties allowing them some peacemaking power. Debates such as these were common throughout the Philadelphia Convention and are responsible for the creation of our current system of separations of power.
The major issues regarding separations of power debated at Philadelphia were veto, impeachment, and appointments. The delegates debated whether the judicial or the executive should be armed with the power to veto legislation. This led to a debate over a council revision as proposed in the Virginia plan. John Rutledge argues judges ought never give their opinion on a law till it comes before them. The delegates agreed allowing judges to intervene in the creation of laws was an obstruction of separation of power, yet they conceded to giving the executive a qualified veto in order to maintain some check upon the legislature.
Who had the power to impeach was debated in addition to the issue of vetoing laws. Rufus King believed that under no circumstance ought the executive be impeached by the legislator. The delegates considered having the Senate impeach and the Supreme Court try the executive. Yet, at this time, the executive was still being appointed by the legislator, which would make impeachment destructive to his independence. By having him elected by the Electoral College, it opened the door for impeachment by the House and trial by the Senate, since they no longer held the power to place the executive into office. Also, this allowed for the Supreme Court justices to be appointed by the executive, since they no longer held the power to impeach the magistrate who put them in office.
Through these debates, the founders produced a system of separation of powers present in our Constitution. George Washington stated in his farewell address, "The exercise of the powers of one department to encroach upon another tends to consolidate the powers of all the departments, a real despotism. Yet, to preserve checks must be as necessary as to institute them." Here, Washington depicts the importance of the coexistence of both a system of separation of powers and checks and balances in our government. The federal court system has played a vital role in maintaining this coexistence.
In Panama Refining Company v. Ryan, the Supreme Court ruled the statute from the National Industrial Recovery Act invalid because Congress had established no primary standard, making the delegation of legislative power to the president too broad. In Clinton v. City of New York, the court found the line-item veto unconstitutional, since it gave the president legislative power by him nullifying portions of bill already passed by Congress. As ruled in United States v. Nixon, the president cannot use executive privilege to impede judicial proceedings. The courts have made sure the branches remain independent enough to carry out their functions, yet also allow checks and some overlapping powers to take place. For example, the check validated in Ex parte McCardle allowed Congress to withdraw the court's jurisdiction if regulated under a congressional act through the exceptions clause. And Mistrata v. United States allowed Congress to delegate power to executive agencies as long as it laid out specific directives.
Madison states in Federalist 51 that in framing a government which is to be administered by men over men, the government must control itself, and the constant aim is to divide and arrange the several offices in such a manner as they may be a check on the other. The founders created such a government that has survived over 200 years, retaining its structure and balance. This concludes our statement. We are ready for your questions.